Roy J.B. presiding.
You may be seated. Calling the case of the People versus Austin Edward Hopkins. Counsel identified for the record, please.
Good morning, Your Honor. Mark Webb on behalf of the people, and also in my office is our intern, Kaylee.
Your Honor, Austin R. Rowe, appearing on behalf of Mr. Hopkins.
You are Austin Edward Hopkins?
Yes, sir.
Previously, you appeared in court and pled to the charge of unlawfully driving away an automobile. That is a felony. It carries a maximum penalty of 5 years in prison. Minimum is discretionary with the court. A pre-sentence investigation report has been prepared. Sentencing guidelines have been determined to be 0 to 11 months. Mr. Rowe, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Anything of a factual nature that you wish to add to, explain, or controvert in that report?
Your Honor, there's two factual matters here. One is on page 7 under mental health. Mr. Hopkins reports he has ADHD, so he would like that added to the mental health section on page 7.
Any objection? Mr. Webb?
No, Your Honor.
All right.
Your
That'll be
Honor,
added.
the second issue is that there's been a statement in the report that Mr. Hopkins has HIDA status for the case involving carrying a concealed weapon. He tells me that he's just on probation for that he did not get the HIDA status on that case.
Any objection to that correction being done, Mr. Webb?
Judge, I defer to Miss Medley. She stated under the evaluation plan that he is currently on HIDA status and is developing.
All right. Ms. Medley, so was he placed on HIDA and has he lost it now, or what's going on with that?
Your Honor, I was just looking up his file in Omni. And it looks like his status is not there.
But do we know whether or not he was placed on it and lost it, or just never got it?
Let me check one more place here.
All right.
It looks like he did not have it. I was mistaken. It was part of the plea agreement, but was not granted.
Okay. All right. We'll make that correction that he was not placed on HIDA. And that'll be in several spots. Page 1 of the CFJ 145 and under the evaluation and plan. So those corrections have to be made. Any other factual matters, Mr. Rowe?
No, Your Honor.
Any objection to the scoring of the guidelines?
No, Your Honor.
Mr. Webb, with those changes made, anything regarding the factual nature of the report or the scoring of the guidelines?
Thank you, Your Honor. I've reviewed the report. I have no additions or other corrections to make to it.
I'm sorry, Your Honor. I think there needs to be one more correction. I think maybe the jail credit, because I believe this pre-sentencing report was written for sentencing sometime in April, probably part of April, Your Honor. I can't remember if it was 12th or sometime like that. And now it's a few days later, so there might need to be adjustment to jail credit, Your Honor.
Well, basically, Mr. Rowe, it looks like bond was posted in this matter back in September, and it doesn't appear to have ever been canceled.
Okay. I guess
I can
that-
tell.
I
Go
guess in
ahead.
that- Pardon me, I guess in that case, it doesn't matter then.
All right. Mr. Hopkins, is there anything you wish to say to the court before the court passes sentence?
No, Your Honor.
Mr. Rowe, on behalf of your client?
Your Honor, on behalf of my client, he's a young man. He's got some issues, but Your Honor, he asked that the court would adopt the recommendation as far as the amount of jail time he's to serve and credit for jail, and also being put on probation, Your Honor. We also asked the court to consider giving him the HIDA status, granting that status. He does seem to qualify for that also, Your Honor.
Mr. Webb?
Judge, I don't remember if you asked me about the scoring, but I agree that the guidelines are correctly scored. As to his sentence, I understand there was a Briggs-Killebrew agreement for HYTA probation. However, I'd ask you to take into account this young man seems to have gone on to engage in some sort of a sudden spurt of a crime spree while he was on probation. He got in more trouble in Isabella and that sort of thing. So other than that, I'd ask you to follow the recommendations.
Have there been any other pending charges besides the methamphetamine charge in Isabella County? Does anybody know?
Your Honor, I believe that it's a delivery manufacturer of methamphetamine, and then there's also a pending probation violation in Isabella.
Well, the court would note that he pled on February 23rd, and we were aware that he was arrested on February 23rd for the controlled substance delivery manufacture of methamphetamine when he put his plea in, and the plea agreement called for the HIDA status at that time. So the court doesn't see anything that has changed since that time that should deny the HIDA status. If the court denies the HIDA status, then he would be allowed to withdraw his plea at this point. So the court will probably follow through with the plea agreement. Are there any victims present that wish to speak to the issue of sentencing? Anybody show up or any contact from the victim, any victim impact statement or anything?
Not that I'm aware of, Your Honor.
All right. In order to punish you for what you've done to attempts to rehabilitate you, deter others from committing similar acts, protection of the community, it'd be the sentence of this court that you be placed on probation for a period of 2 years as a home youthful trainee assignment. Along with the statutory terms of probation, you're going to have the following special conditions. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be with anyone you know to possess these items. You must not engage in any assaultive, abusive, threatening, or intimidating behavior. You must not have a verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your placement on probation or release from jail. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must not have any verbal, written, electronic, or physical contact with Bradley Cohen, either directly or through another person. You must make genuine efforts to find and maintain legitimate employment of minimum 30 hours a week. Court will sentence you to the 122 days jail with credit for 122 days served. You must pay a $68 state cost, a crime victim's assessment of $130, court costs of $500, a fine of $500. How much are you charging for attorney fees, Mr. Rowe?
$500, Your Honor.
All right, so $500 in court-appointed attorney fees. The court's going to order you to do 100 hours of community service. If you successfully complete those 100 hours, the court will reduce your fines and costs by $600. The probation officer of this court or any other supervising agent may, pursuant to MCL 771.4, apprehend, detain, confine a probationer who is in violation of probation condition or who is conducting himself inconsistent with the public good. You're not allowed to use, purchase, otherwise possess recreational marijuana or be in the home or company of anyone who uses or possesses recreational marijuana. You must not possess, purchase, or attempt to purchase anything that contains ephedrine or pseudoephedrine without first obtaining permission from your field agent. You must set up an installment payment agreement with the Clare County Clerk's Office within 30 days of your release from jail. You must pay restitution to all victims if any is ordered. Has anybody put in a request for restitution?
Not that I'm aware of, Your Honor.
All right. Did they return the car?
I don't know.
All right. At this point, we'll set restitution at 0, but if a report comes in and whatever it is, that's what you're going to have to pay, Mr. Hopkins. And the court's going to assess you $30 a month for supervision fee, unless you're already paying that fee on another case. And if they put you on electronic monitoring, that fee will be increased to $60 a month. If you're currently being released from another case that you were paying on it and you're not paying any supervision fee, then this would kick into effect. If you do everything you're told, Mr. Hopkins, and you stay out of trouble, you won't have this as a conviction on your record. If you fail to stay out of trouble and do everything you're told, then you're going to come back in front of this court for sentencing, and the court doesn't have to follow those 0 to 11 guidelines. The court can recalculate them with your current record at that time. So it's best for you to follow all the rules and do what you're told, Mr. Hopkins. Good luck to you.
Thank you, Your Honor.
Your Honor, I believe this concludes my cases before the court this morning. Have a good day.
All right, thank you.
You're all set, Mr. Hopkins?
Thank you.
I believe that your next case is also.
Do we have Ms. Tomczyk online? Does she need to talk to him?
Good morning, Karen.
Morning.
All rise. 55th Circuit Court is now in session. The Honorable Roy G. May presiding.
You may be seated. On the case of the people versus Justo Charles Guzman. Counsel identify for the record, please.
Morning, Your Honor. Mark Webb on behalf of the people.
Morning, Your Honor. Karen Tomczyk appearing on behalf of Mr. Guzman.
You are Justo Charles Guzman?
Justo Charles Guzman, yes.
Okay. Previously, you appeared in court, pled to the charge of felonious assault or assault with a dangerous weapon. That is a felony, carries a maximum penalty of 4 years in prison. You also pled to the charge of domestic violence. That is a misdemeanor, carries a maximum penalty of 93 days in jail. A pre-sentence investigation report has been prepared. Sentencing guidelines on the felony have been determined to be 0 to 17 months. Ms. Tomczyk, have you had an opportunity to review that pre-sentence investigation report with your client?
I have, Your Honor.
Is there anything of a factual nature that you wish to add to explain or controvert in that report?
Nothing of a factual nature, Your Honor.
Any challenges to the sentencing guidelines?
Yes, Your Honor.
Alright.
I see that just one, the offense variable number 4 has been scored, Your Honor. That requires that there be some showing that actual professional counseling was needed. There's been no showing that the victim here even tried to, attempted to, or needed professional counseling.
Mr. Webb, any response to that?
Yes, thank you, Your Honor. Judge, the instruction for OV4 states that score 10 points if the victim's serious psychological injury may require professional treatment, and the fact that treatment has not been sought is not conclusive. I think that somebody who's been assaulted in this way may not have any immediate psychological effects, but those are always a possibility.
Ms. Medley, on behalf of the Department of Corrections, anything regarding this aspect?
Your Honor, I do believe that OV4 should be scored at 10 points. Per the description of the offense, that the victim could at some point need some sort of treatment for PTSD or some other psychological issue.
Apparently from the pre-sentence report, there is nothing from no crime victims impact statement that was provided. Was there anything in the police report that would be relevant to this issue, Mr. Webb?
I don't believe so, Your Honor.
All right. We have to have some kind of a factual basis to justify it, just not on the issue that normally a person would go through that and have some issues. So the court is going to grant the objection and score OV4 at 0. That changes the OV level to 21. Does that change anything, Ms. Tomczyk?
It does not, Your Honor.
All right, so it still leaves it level 2 and 0 to 17. Is that correct?
That is correct, Your Honor.
All right. Mr. Webb, anything regarding the factual nature of the report or other challenges to the scoring of the guidelines?
Your Honor, I've reviewed the report. I have no additions or corrections to make to it, and I believe the guidelines are correctly scored.
All right. Mr. Guzman, is there anything you wish to say to the court before the court passes sentence?
No, Your Honor.
Ms. Tomczyk, on behalf of your client?
Your Honor, in this case, there was a Briggs-Killebrew agreement to no initial incarceration. I would note that Mr. Guzman is currently in Isabella. He is serving time. However, he is serving time on an offense that was known at the time that that agreement was made. So I see no reason to deviate from that agreement. We ask that you follow the plea agreement in this case, Your Honor.
Mr. Webb, on behalf of the people?
Your Honor, I also ask you to follow the plea agreement and the recommendations. However, I'm not sure if there's already if there was as part of his bond, a no contact order. I have an agent, Brenda Leos, from Isabella County, notified Mr. Wing that his defendant has been constantly trying to call Mrs. Guzman from March 15th to April 18th, at least 37 times.
Whoa.
Other than that, I have nothing else.
All right. Are there any victims present that wish to speak to the issue of sentencing?
I don't believe so, Your Honor.
There's nobody in the courtroom and nobody's called in on Zoom, so. The court has reviewed through the pre-sentence investigation report. Does provide for sentencing guidelines of 0 to 17 months. As stated earlier, the court did receive a letter from PMS Towing and Recovering stating that Mr. Guzman was a good employee and they would like to have him back in their employ. In order to punish you for what you have done to attempts to rehabilitate you, deter others from committing similar acts in protection of the community, be the sentence of this court that you be placed on probation for a period of 2 years, along with the statutory terms of probation and the following special conditions. You must not use or possess alcoholic beverages or other intoxicants or enter any places that serve alcohol. You must comply with the requirements of alcohol testing as directed by the field agent. You must comply with the requirements of drug testing as directed by the field agent. You must not use or possess any controlled substances or drug paraphernalia unless prescribed for you by a licensed physician or be within anyone you know to possess these items. You must complete any outpatient or residential substance abuse treatment when referred by the field agent. You must complete a substance abuse assessment when referred by the field agent. You must perform 100 hours of community service. If you successfully complete that 100 hours, the court will reduce your fines and costs by $600. You must complete a psychological evaluation when referred by the field agent. You must complete mental health, domestic violence, battery intervention, or other recommended treatment following assessment by a qualified community-based service provider. In addition, you must complete an anger management program. You must waive confidentiality and allow any treatment program that you are required to attend to disclose information to your field agent. You must not have any verbal, written, electronic, or physical contact without permission of the field agent with anyone you know to have a felony record. You must not change your residence unless you first obtain written permission from the field agent. You must not use any object as a weapon. You must contact the supervising field agent no later than the first business day following your release from jail. You must comply with all written and verbal orders made by the field agent. You must allow the field agent into your residence at any time for probation supervision. You must submit to a search of your person or property without the need of a warrant if the field agent has reasonable cause to believe you have items which violate your conditions of probation. You must report any arrest or police contact, loss of employment, or change of residence to the field agent within 24 hours, weekends and holidays accepted. You must notify the field agent of service of any personal protection order upon you within 24 hours of that service, weekends and holidays accepted. You must be in your approved residence between the hours of 10 p.m. and 5 a.m. unless excused by first obtaining written permission from the field agent. You must not have any verbal, written, electronic, or physical contact with Audrey Guzman, either directly or through another person, and you must not be within 500 feet of her residence, school, or place of employment. So stop calling her. You must make genuine efforts to find and maintain legitimate employment of a minimum of 30 hours a week. You must comply with DNA testing, pay a $60 fee, pay $118 in state costs, crime victims assessment of $130, pay a supervision fee of $30 a month. If the probation department decides to put you on electronic monitoring, it will be $60 a month. We will not charge this in this case as long as he's paying a supervision fee in another case. But if he's not paying a supervision fee in another case, then it gets installed on this case. Must pay court costs of $500, a fine of $500. How much are you charging for attorney fees, Ms. Tomczyk?
$1,760, Your Honor.
And $1,760 in court-appointed attorney fees. You are entitled to appellate review of your conviction and sentence. If you're unable to hire your own attorney, the court will appoint an attorney for you and furnish the attorney with the necessary records and transcripts to perfect an appeal. The request for the appointment of appellate attorney must be made in writing within 42 days, sent directly to the court. Please sign the notice of appellate form, rights form when you're presented with it. Probation department can add any other terms of probation on it, like they wish to have on there. Bond is canceled. Do you need to talk to him, Ms. Medley, or does he just need to contact the probation department upon his release?
Yes, just, you'll need to get in contact with us after your release from the Isabella County Jail.
All right, you're all set, Mr. Guzman. Good luck to you.
All right, thank you, Your Honor.
I believe that completes all my matters, Your Honor.
I do believe that's true. All right, thank you. You're all set.
Me too, Your Honor.
I'll be not mine or? We'll take a short recess.
All right.
We're here, but no video.
Can you see everybody else on the screen, Greg?
Yeah, I can see the circuit court. I can see you. There,
Okay, now
there-
just gonna come in the courtroom, so now you have to be,
Roy J. Meek presiding.
You may be seated. In the case of Daryl Raymond versus Gregory Bentley, counsel identify for the record, please.
good morning, Your Honor. Tara Hovey appearing on behalf of Greg Bentley.
And you are Daryl Raymond? You need to unmute. Can't hear you.
That is correct, sir. Can you hear me now?
Yes. And you are Greg Bentley?
Yes, sir.
All right. We're here today on 3 motions: a motion to terminate, a motion to extend the PPO, and a motion to show cause, hold the defendant in violation. Have you received those copies, Ms. Hovey?
I have, Your Honor.
All right. Mr. Raymond and Mr. Bentley, would you please raise your right hands and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
I do.
All right. We're going to start with the motion to terminate. Do you wish to proceed with the questioning, or you wish to court the question, Mr. Raymond, Ms. Hovey?
Your Honor, I can question Mr. Raymond.
Go ahead.
Thank you. Mr. Raymond, you filed a motion for a PPO, correct?
Yes, ma'am.
And in that motion, sir, you allege that the issues between you and Mr. Bentley actually began on March 18th, correct?
Yes, ma'am, I believe so.
With regard to that, sir, you and Mr. Bentley actually have a joint property line, correct?
Yes, ma'am.
And with regard to that joint property line, Mr. Bentley has a fence on his property, correct?
Yes, ma'am.
Prior to March 18th, you requested from Mr. Bentley or discussed with Mr. Bentley using that fence to contain some cattle on your property, correct?
Yes, ma'am.
And you and Mr.
Well,
Bentley,
I'd like to rephrase. I did not request to use his fence. I requested to use his existing poles to attach my fence to that.
okay, so you wanted to use the poles of his fence.
Yes, ma'am.
And you were advised that that fence was actually inside the property line, correct?
There's 2 sections of the fence. One particular portion of the fence is exactly on the property line. And then there's a section out by the road that is 100% on his property. Yes, ma'am.
Well, with regard to those posts, sir, you didn't have it surveyed, correct?
I'm sorry.
You didn't have a survey done on the property, correct?
No, ma'am.
And Mr. Bentley told you he did have a survey done when he put the fence in, correct?
Yes, ma'am. That's what he said.
And Mr. Bentley told you the fence was an inch in the property line, correct?
I can't say one way or the other on that, ma'am. My
Okay.
understanding was that the fence was the property line.
But you knew it was his fence.
Yes, ma'am.
And with regard to that, you and he discussed your use of that fence, correct?
Yes, ma'am.
And he told you what you needed to do in order to be able to use his poles and how he wanted it to go if you were going to use his fence poles, correct?
Yes, ma'am.
And on March 18th, sir, you and Mr. Bentley actually were met at that fence line, correct?
I believe so. Yes, ma'am.
And Mr. Bentley on March 18th told you that he disagreed with how you had hooked the fence to his fence, didn't he?
On the 18th.
No, ma'am.
Okay,
That's
sir,
not-
somebody just whispered to you.
No
So
one-
who's feeding you the information?
I don't know what you're talking about. I have another person sitting here, but I heard the whisper also.
Okay, well, I'm gonna direct then if that was you, Greg or Linda, you cannot talk, okay?
Okay.
Thank you. So on the 18th, sir, you guys talked about the fence, and at that point, Greg told you he didn't want you to attach anything to the wood fence, correct?
Well, ma'am, on the 18th, I believe, when what you're talking about, Mr. Greg
came up along the fence by my house. And I believe this is the day that my cows were delivered, and started screaming at me.
Sir, I'm gonna ask the question, okay, again. Because I'm not asking about that. I'm asking about, Mr. Bentley told you not to connect your fence to his wooden fence, correct?
He told me that my use of his fence was no longer granted.
Okay, and that occurred on the day your cows arrived?
Yes, ma'am.
And that would have been March 18th?
I believe so.
And with regard to that, sir, one of the reasons he told you that you couldn't use your fence was because you hadn't repaired it where he told you needed to be repaired, correct?
No, a repair was not in question at that point in time. We had a misunderstanding. He had wanted me to extend the cage wire fence that he had already in place up past his wooden fence for extra security. Like I had said, that was a misunderstanding, and I tried to do the right thing, and I went to his house, spoke with him, and tried to accommodate his wishes.
And that occurred on March 18th?
I believe so.
Well, in your request for a PPO, you tell the court that everything started on March 18th. So on March 18th,
Yes,
there
ma'am.
was a dispute, or you recognize that you didn't understand what he had requested of you?
Could you restate that, please?
Yes, on March 18th, is it your testimony then that there wasn't a dispute? It was you had misunderstood what he wanted in regard to his fence.
No, there was a huge dispute, ma'am. And later on, after the initial dispute, maybe an hour or so, I did not know what the dispute was about. And so I went to speak with him. Because I didn't want any problems with him. I wanted to do the right thing. I drove over to his house, told him, Mr. Gregg, I'm sorry if I've offended you. That is not my intent. I wanted, blah, blah, blah. I want to be peaceful. I want to do right by you. And I tried to do the right thing, but that was not ever going to happen, apparently.
Well, let's backtrack then. You said that there was a dispute prior to that. What are you referring to as a dispute? Did he tell you to take your stuff off the fence at that time?
I didn't hear the last part. I'm sorry.
Did he tell you to get your stuff off of his fence at that point?
Yes, that was part of the initial encounter, but it wasn't like a conversation. It was belligerent yelling, and you couldn't follow it.
Okay, so this whole thing started with him telling you to remove your stuff from his fence, correct?
I don't remember the exact thing that came up first, but that was one of the things that got mentioned on that very first encounter.
Okay, and so when you tell the judge that this all started on March 18th, that is what you are referring to?
Along with him yelling obscenities, and also yelling about my wood stove that's in my front yard.
This all happened on March 18th?
Yes, ma'am. First encounter prior to that date, Mr. Gregg was nothing but a pleasant, sweet guy who I enjoyed conversating with.
And well, actually, with regard to that, you're familiar with the fact that Greg walked along the fence line every day, weather permitting, with his dogs, correct?
Yes, ma'am.
And that's something you observed last summer as well?
Yes, ma'am.
Okay, and with regard to that, so on this day of March 18th, prior to that time, you'd had no issues with Mr. Bentley?
Not at all, ma'am. A lot of people in the community have
Sir, I don't want to hear
said
about
to me
other
that he
people,
wasn't such.
sir. I asked you a question that can be answered with yes or no. So you personally had no issues before March 18th.
No, ma'am.
Okay. And you told the judge that on March 18th, that's when you guys started your problems. And then you indicated in your application for the PPO that the threats were that he threatened to dismantle the fence. Is that correct?
Absolutely.
And that is the fence that you put on his fence, correct? Where you attached it to his fence?
Where I attached it to his poles, ma'am.
Okay,
That is
well,
correct.
you didn't purchase those poles, did you?
No, ma'am, I did not.
And you know that he claimed that the fence was on his side of the property line, correct?
No, ma'am. My understanding was the metal fence was the property line. He did purchase the fence. And I was well aware that his wooden section of the fence was on his property.
With regard to your application for the PPO, you claimed that he threatened physical violence. What was the physical violence? What was the threat?
Ma'am, I don't not answer this without using any profanity, so I'm going to try my best.
No, go ahead and say whatever was said, okay?
I can say whatever was said?
Yes.
Yes, ma'am. Okay, so after I was asked to remove my fence from his poles and put up metal fencing along the remainder that was along his wooden fence, I had started immediately to put my own poles in the ground, run my new wire, and also I had went and purchased cattle panels, which is a really thick, heavy gauge steel fence that way better than stronger than his existing fence, because I didn't want to have these problems. He come out there, stood on his side of the property line, started swearing.
You're not answering the question. Why don't you repeat the question, Ms. Abbey?
You said that there was a threat of physical violence. What was the threat of physical violence?
Well, during that encounter at the property line, Mr. Gregg was telling me how much of a big piece of shit I am, and that he should not expect less from a Trump supporter. But he said if I come over to his side.
What was the threat, Mr. Raymond? Answer the question. What was the threat?
Yes, sir. The threat was Mr. Gregg said that he would kick my ass if I come over to his side he would fuck me up if I came over to his side of the property line.
So he said, if you come on my property, I'm gonna fuck you up?
Yes, ma'am.
Okay, and did you go to that side of the fence?
Absolutely not.
And did Mr. Bentley ever come to your side of the fence?
He did not walk over to my side of the fence, but later on when he was breaking insulators, he was leaning over with a hammer.
Okay, well, let's keep going, okay?
Yes, ma'am, sorry.
You mentioned in your request for the PPO that he filed a complaint with the township, correct?
Yes, ma'am.
Now, he filed a complaint regarding blight, correct?
The word blight was never used to me, but he was complaining about my wood stove placement and my cattle shed that I have down there. Yes.
Okay, and with regard to those, the township informed you that you had to comply with setbacks in regard to those, correct?
No, ma'am. Right now we are in the process of having a variance meeting coming up. And because initially the township had said that I'm not doing anything wrong and issued me a permit initially.
And then the township revoked that permit and told you either comply with the setbacks or apply for a variance, correct?
Yes, ma'am.
So the township did indeed find some issues with the way you had your stuff, correct?
Currently, there is an issue with the zoning code. One particular code says 10 feet, the other one says 50. So there's a question. Yes, ma'am.
And you're having a variance hearing.
Yes, ma'am.
Okay. So now you also told the judge that he destroyed your personal property. Was that where you said he was leaning over the fence and breaking those insulators?
Well, yes, ma'am, but basically there's two different sets of insulators. There's one that was on the wooden post that.
Okay, stop right there. On his wooden post?
Yes, ma'am.
Okay. And where were the other ones?
The other ones were on the metal posts that I had installed. I have a
Okay.
picture of that if you'd like.
And with regard to the insulators on your post, were those damaged in any way?
Yes, ma'am.
And where were those ones at?
Up by the road on the fence that I installed to remove mine from his fence.
Is that the pole that you ultimately cut down?
The wooden post that I cut down, is that what your question is?
Yes.
No, ma'am.
Okay. With regard to the other insulators, those were on his wooden post, correct?
Yes, ma'am.
And those were what you left behind on his property, correct?
Yes, ma'am. Mr. Gregg made it very clear that I was not welcome to be on his property whatsoever.
Okay, so you removed your wire, but you didn't remove the insulators, correct?
Off the wooden post, yes, ma'am.
And he removed those insulators later, correct?
Yes, ma'am.
And those are the ones that you observed him breaking off?
No, ma'am.
Okay.
I observed those, but those are not the ones that I am complaining about.
And you're saying there were other ones that were broken off?
Yes, ma'am.
And where were those at?
They were on the metal posts that after I had to move the fence over, they were part of my fence and my posts and my fencing system.
And they were broke off with a hammer?
I didn't see him physically do it, ma'am. But
So you didn't, okay. So the insulators were off your post and you didn't see him actually do that part? So that's a yes or no?
I did not physically see him do that.
Okay, and with regard to these insulators being, so they were removed off your post, was that before or after the cattle was put into the fence?
Are we talking about the wooden post or the metal post?
Well, I'm talking about the insulators that were on your post that were removed.
That was after the cattle were already in there.
Okay, and so you don't know how those insulators came off, but you believe that Mr. Bentley did it?
Yes, ma'am.
Okay. And so the destruction of property, that's what you're referring to, correct?
Yes, ma'am.
Now, you alleged in the PPO that charges had been filed against Mr. Bentley for destruction of property. You said that he was seen hitting the fencing material with a hammer and charges were filed for destruction of property. That's
Yes,
not
ma'am.
a true statement, is it?
Yes, ma'am, it is a true statement. I personally did not see him actually strike the fence, but I have a gentleman here with me also who was standing right there and was standing right in front of the fence pole when this happened and was almost struck in the face with this hammer plier thinger.
And this was in regard to your post or his or Greg's post?
My post, ma'am.
Okay, and you weren't present.
I was, I had my back to the situation. When I heard the commotion, I turned around and witnessed the rest of the encounter.
And the
But like
rest
I
of
said-
the encounter was what?
Mr. Gregg being hysterical, more profanities, and just craziness.
Telling you to get your stuff off of his property.
No, ma'am. I was not anywhere near his property at that point in time.
Okay, he's breaking the insulators on his fence at this point?
No, ma'am, this was on my metal stake, which I have a picture of if you'd like to see it.
With regard to that, was the metal stake the one that Greg had that you moved with the
I
survey
never-
stake on it?
I never moved Greg's survey stick, anything. I have no interest in messing with Greg. This is not a game for me.
Well, with regard to this, what were the other additional issues then? You said that there was additional issues. What were they?
Okay. Well, ma'am, with, like I said, Mr. Greg has, unplugged my fence.
Let me stop you there if I can. With regard to unplugging your fence, how did that occur? Do you know?
Well, ma'am, I assume that he says in his article that he, clipped the ties on the fence, which is true.
All right,
And,
let me stop you so the judge can catch up to us.
okay, yes, ma'am.
You strung an extension cord from your house out to your electrical fence for your cattle, correct?
Yes, ma'am.
And you secured that onto Greg's fence, correct?
Can you back that up, please?
Yes. The extension cord was attached to Greg's fence, correct?
Yes, ma'am.
And the things that you used to hook it onto his fence, he unclipped those, correct?
Yes, ma'am.
Because he told you he didn't want you to have anything on his fence, correct?
Later on, yes, ma'am.
Okay. And with regard to that, that's when you believe that the cattle were unplugged, or the electrical fence was unplugged?
Yes, ma'am. It was, the fence was, the electric cord was already off his, fence and laying along my side of the fence. And then I discovered that the fence isn't working. And later throughout that day, I'm trying to figure out the problem and I see that it's unplugged, laying out 15 feet on my side of the fence, which that's,
So the cord, was this the same day that he took it off of his fence?
I don't think so, ma'am.
Okay.
It was during all this, it was part of these arguments that we were having.
About whether you could use the fence or not? His fence?
No, ma'am. It had already been well established that he did not want me to use the fence. During that time, I was putting up my own fence and the gentleman would come out there and harass me constantly.
With regard to that, never mind, I'll withdraw that part of the question. With regard to the complaints in the township, township also made you move a car, correct?
Just for clarification, ma'am, the township never instructed me that I had been in violation of anything. I did remove the car, but that was to try to ease tensions with myself and Mr. Greg.
Well, and with regard to that, the township told you that that was one of the issues, correct?
I believe so.
Okay. And sir, this all happened between the time of this March 18th and when you applied for the PPO on April 6th, correct?
Probably, yes, ma'am.
And you now have the fence up
Yes, ma'am.
and you're not encroaching on Mr. Bentley's fence now?
No, ma'am.
With regard to the PPO violation that you filed, you requested that Mr. Bentley, or I'm sorry, you advised that Mr. Bentley was walking along the fence?
That's correct.
And was he walking in the mowed area that he usually walks in?
Yes, ma'am.
And was his wife present?
I didn't see her, no.
I'm sorry, was this before or after the PPO was served?
It was after.
And so you filed two of them, correct? One on April 23rd?
Two PPOs? What are we talking about?
2 violations.
The one
I had
is a motion to extend, where he's asking that he be limited to not more than the 20 feet, but to 500 feet from his property.
Okay, I apologize, Judge. Mr. Raymond, with regard to the April 23rd, Mr. Bentley and his wife were walking their dogs along the fence, or not along the fence, but in the field, correct?
Are you talking about the violation?
Yes.
No, ma'am, I didn't see Mrs. Bentley at all there. I witnessed Mr. Gregg on one side of the field. By the time that, this is as I'm pulling in the driveway, by the time I got to my house, he was standing right beside my pole barn, which is within the 20 feet limit. I snapped his picture. I called the police because that's what I was instructed to do.
And you have a picture of him within the 20 feet of the property line?
Yes, ma'am.
I'd like to see that.
It should be part of the case number that's on my paperwork there with the court.
Judge, I don't have any pictures that were attached to the paperwork I received. Do you?
There was no pictures attached. It just says see case number 21-113-3, which probably is a police report number.
Yes, ma'am. The officer that came out here had asked me to send that picture to him. I mean, I can pull,
Do you have a copy that you can show to the Zoom there?
if you give me 1 second, I can pull it up. Yes, yes, sir. Trying to get the lighting.
And with regard to that, I'm really struggling for perspective on that.
Would you like me to zoom in, zoom out?
I'd actually like you to upload it. Can you email that to yourself or something?
I can share it to you if you'd like. I don't know how to do all that.
Is there a timestamp on your photo?
Probably. I don't know how to check that. Okay, do you have an email address or some way to send it to you?
Send it to TSHOVEY@gmail.
Okay, it should have sent, I think.
Okay, and with regard,
What day did this occur?
I couldn't hear you, sir.
What day did this occur?
Believe on the 22nd. 24.
You may proceed.
Judge, I'm trying to be able to show that to you.
Uh-oh, I lost him.
I'm still here.
We can still hear you, Greg. I just moved the screen, okay?
Okay.
Can you see the picture?
No.
Daryl, can you see it?
Yes, ma'am.
Okay. With regard to that, this is the picture you claim happened on the 23rd?
22nd, I believe, ma'am.
Okay. And you don't have any timestamp or anything on here?
Hold on a second. I don't know how to check the timestamp. You not do a timestamp check?
Well, let me ask you some questions. Greg mows the first part of the fence over into the hayfield, correct?
Yes, ma'am.
Do you know how far over to the hayfield he mows?
No, ma'am. I would guess probably two more widths.
So 10 feet, 12 feet?
Probably.
Okay. And with regard to that, he's out away from the fence, correct?
He is walking directly on the opposing side of the fence there. Yes, ma'am.
Okay, in the area that he regularly walks in,
Yes, ma'am.
and that, well, I can't quite see because his feet are kind of behind the equipment there.
Yep.
Okay.
I have that timestamp now if you'd like to see it.
What is it?
April 23rd, 2021, Friday at 8:39 a.m.
And your testimony is that you weren't home when you observed him walking, correct?
Yes, ma'am. I had taken my children to school. When I showed back up, he was on the opposing side of the field. When I made it up to my house, my driveway's pretty long. When I made it up to the house, he was standing right there by my garage, staring at me. I pulled out my phone to take a picture, and so he started kind of high stepping, walking fast, trying to get out of the area.
Sure, I'm gonna try and share the screen again. With regard to give the judge a perspective, this would be your house back here, correct?
Yes, ma'am.
This is the fence line that we're talking about.
Yes, ma'am.
This would be Greg's deck, correct?
I've never been on his deck, but it appears to be yes.
Okay. And this is the fence line that we're talking about, correct?
If you're talking about the one out by that red barn, yes.
Can you see the photo I have up? It appears to be from the road.
I can, I'm seeing the one from his deck right now.
See if we can do her again.
Yes, ma'am.
Did it come up that time?
Yes, ma'am.
Okay. And so when we talk about where the fence line is, that's your house there,
Yes, ma'am.
Greg's barn here.
Yes, ma'am.
Well, this is part of the yard where he mows, correct?
Yes, ma'am.
That's about the distance that he generally mows all the way back, correct?
It looks a little bigger, but ballpark, I'll say yes, sure.
Okay. And now this up here has actually been part of, is not reflect what is currently going on there, correct?
No, ma'am, that particular section, as you can see, my pole that's kind of in that open area, that's
This one here?
yeah, that has all been removed and it's just currently the pole to the right.
And you
And
removed
then-
that because Greg informed you you were on his property, correct?
Yes, ma'am. And I removed everything like that fence that connects his fence and my fence is gone. Yep, that right there, that's gone. That pole is gone.
What
And
about this bigger one here?
no, that is there. That has to be there to make that corner.
Okay. And see if I can give you another. With regard to the connectors that you were talking about for the judge. I wish this was easier. It's easier in person than it is this way. Are these the types of connectors that you're talking about?
What could you rephrase? What are we talking about?
You were talking about the connectors removed from your fence?
No, ma'am, that is not the kind of connectors that we're talking about.
With regard to that, I'm not sure if I have a good picture of the,
I got a picture right here if you'd like to see. This is what I'm talking about. The top insulator is smashed. It is clearly on my side away from that wooden fence, which is basically what the photo that you just showed me with the post. This is just right after that.
so his wooden fence back here in the back.
Yep, the wooden fence is back here in the back. That's his. And then when I
Okay.
put up my new fencing, I used these poles and he reached over and smashed it with a hammer of some sort of something.
Okay, and he also smashed the ones off of his fence?
Yes, ma'am.
Okay, how many of your insulators were broken?
Are we talking about on my fence or
On
altogether?
your fence?
As far as I know, just the one.
Okay. I have no further questions, Judge.
All right. What I'm gonna do is I'm gonna take a little short recess. I only gave this for an hour. Maybe if you wanna go in a breakout room with Mr. Raymond and talk with him, maybe you could settle this. But I'm gonna hear the next case, and then when we're done, we'll bring you back in. Does
That'd be
that
wonderful,
sound okay?
Yes, Judge.
All right, so if you put Mr. Raymond and Ms. Hubby in a breakout room.
I don't know what's going on here.
Mr. Raymond, may I ask you to join the breakout room? Mr. Bentley, I'm going to put you back in the waiting room, okay?
I'm sorry, Tara, what was that?
This is the clerk speaking, and we are going to put you back in the waiting room. We're gonna hear another case and then we'll come back to you, okay? I'll bring you back in as soon as we're done.
Okay, thank you so much.
So I have Jeff Brown and his attorney. But I do not see
Okay. Let's bring him in.
Okay.
Give me the file.
Good morning, Mr. Hicks.
Morning.
Do you expect your client to appear?
He's in the room with me.
Okay. Okay. Good morning, Mr. Brockway.
Good morning.
Do you, is your attorney planning to appear?
Yes.
Oh, I see now. I see. All right. Just showed up.
There it is.
Calling the case of Jennifer Brockway versus Jeffrey Brockway. Counsel identify for the record, please.
Your Honor, James Hicks here on behalf of Jennifer Brockway.
Yeah, good morning, Your Honor. Anthony Jenkins appearing on behalf of Mr. Jeff Brockway, who's appearing via Zoom.
Right. And we're here on a objection to a uniform support order that was dated 3/18/21. Did both counsel receive the letter from Jamie Raymond regarding this order?
Yes, I did, Your Honor.
Is that a yes from both counsel?
Yes.
All right. And then you filed this objection, and the friend of the court believes that you're not entitled to file the objection. But your objection alleges that our actual income is being imputed a little more than what it was.
Yeah, I've talked with Mr. Jenkins, and I believe the calculation for his client is probably correct because his taxes did include the other sources of income that we didn't know it included. We've reviewed that together. My only real objection at this point is that my client is working as many, at that time, is working as many hours as she could, and for some reason, and we just don't know why it's on there. She was imputed income to increase her income from the the employment that she had all the way up to 3,500, and she wasn't making that. It seems to be that she had a temporary job while she wasn't working to make income while she was laid off from her one job due to COVID. And then she went back to her other employment. It looks like they added both employments together, even though they weren't simultaneous, to come up with the 3,500. And then when she was acknowledged as no longer working that temporary job, that income wasn't decreased and taken off of her pay. Her full-time pay at the Ascension where she's working, which has actually only been like 27 hours. But that's all, that's all the hours she's working there. But she's not at the $3,500 income, and we didn't know why that extra income is being imputed, and we're trying to resolve that. So, and at this point, I mean, and it might be moot anyway, because at this point she ended up, in order to get full-time employment, going to McLaren. So her full-time employment is now $1304.31 every 2 weeks, which gives her $28.26 a month. And it is full-time employment now. It's no longer the 25 hours, but she took a pay cut to $21 an hour in order to get full-time employment so she could insure herself. So. And Jason with dental. She provides dental for the child through her employment. So the pay is actually $28.26. I don't believe there should be a month, and I don't think there should be any imputed income here to increase her to $3,500. She can't really do the extra hours and all that. She is full-time at McLaren.
Do you agree, Mr. Jenkins?
I don't have any reason. I haven't seen a pay stub. I don't know.
I just got the pay stub. I just got the pay stubs now. Apparently she switched jobs since this, since this objection was filed, she switched the job. She's been there a couple of weeks now.
Yeah, I don't know what she makes. I mean, I don't disagree or agree. I have no idea. I knew why they imputed last time, and they imputed back. I talked to Mr. Higgs about it yesterday. They imputed back in September. They imputed back in December. So it looked like we talked about that yesterday. I could understand why they imputed, because she was only working, I believe, 27 hours a week. So they imputed her up a little bit. She was making $24.99 at that time. So they imputed her up to about $3,500 a month. I don't know all the math on that, but there was a little bit imputation. So I don't know how many hours she's working now, but if, she says full time, but I don't know if that's 40 hours or what it is, but
Actually 36 hours full time at McLaren.
All right, what I'm gonna do is, we'll reset this hearing for about 2 weeks away. And Mr. Higgs, you can present your evidence to Mr. Jenkins. If the two of you can work it out, you can do a stipulated order as to what it should be. And if not, then we'll come back and I'll want you to file an amended objection with your facts and your amounts, and I'll want a response filed too.
Yep, that's fine.
Thank you, Your Honor.
All right.
Yeah.
All right.
Thank you for your guidance on that, Judge. I do believe that would be an appropriate remedy to this, hopefully. So thank you.
That would work. Thank you, Your Honor.
All right. Thank you. You're all set.
Okay. Have a great day.
Thank you. Goodbye.
I'll take a short break before we bring everybody else back in. All rise. 55 circuit court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. Recalling the case of Daryl Raymond versus Gregory Bentley. We've had some discussions.
That is correct, Your Honor. We do have a resolution of this matter. In this matter, the PPO will be dismissed. Mr. Bentley will remove the camera that is located on his barn that is pointed towards Mr. Raymond's house. That will be removed. The other camera that is pointing towards the road area will stay, but it will not be, the direction with which it's pointing won't change. The parties will not communicate with each other or harass each other, short of obviously some important issues such as the animals are out or something along those lines. And then the issue with regard to the township and the variance, the township will do what the township does. Is that a fair statement, Mr. Raymond?
Yes, ma'am.
Thank you. And Mr. Bentley, you heard what I said as well?
I am, yes.
And you're in agreement as well?
Yes, ma'am.
Okay. Judge, I think that's the full and settlement of this matter.
All right. You're gonna draft an order to that effect?
I will, Your Honor.
All right, the court will sign the order upon presentation. I want to thank you for everybody for cooperating and trying to resolve this matter. We are in recess.
Thank
All rise.
you, Mr. Raymond. Thank you, Mr. Bentley.
Thank you.
Yes, ma'am.
Thank you, Judge. The host has removed you from this meeting.
Okay.
So, I
So
don't know,
just the temp order that goes
Yeah,
on, the
because
judge may want to
we
sign.
don't have a renewal from Wayne here because. Oh, but we have an order to terminate.
So we are gonna need a lien. You can sign that after we're done. Oh, whoops. One goes back.
Probably.
He does need.
I have the order to terminate.
Order of hearing on violation.
Um,
And we don't need this.
Okay.
If you find this, I'll
We
leave
have
you
this one
with
too.
the. See you in a minute.
Right.
lost my pen.
Is this it?
It is.
How did it get over here?
I had to start the computer because I wasn't sure if anybody was gonna get
Oh.
So I was gonna hit record and then go over and do that.
Yeah.
I do, I don't have, I mean, I gotta get this to the judge for this case that's coming in next. Just pay it for the answer.
That's a very, there's no judge yet.
So they would do it after.
Okay.
Yep.
Just wanted to make sure.
Yeah, both of them had attorneys, so I knew they would in Hannah.
Tom, I'm guessing the individual, the leader client that's in the waiting room is Miss Clark, or Mr. Clark?
Correct.
Miss,
No,
okay,
I have Miss Clark.
okay. I think we're gonna do the dope versus dope, and then I will let, the other party in.
Can you go see if it prints out the QSR, please?
Actually, I think it is people in the system.
Can you hear us?
I hear you, Jeff.
You didn't want to just over, Greg.
Yeah, come this way, just stay there.
Is that the judge?
No, that's Todd Dietrich.
Oh, the attorney.
Yeah, he's your wife's attorney.
Yeah.
Can you hear me, Todd?
Okay, hold on just one moment, Mr. Juniak.
Oh, all right, sorry.
That's okay, we have one more hearing before yours, but I'm just bringing you guys in so we can make sure audio works. I'm just gonna leave you here in the courtroom because it's gonna be a very quick thing that we do before your hearing. But for time
Okay.
being, I'm just gonna go ahead and place you on mute,
You can
okay?
hear that? I can't hear that.
Do you want Todd and I to intervene in this first case you have, if we have to?
Well, Todd's the attorney on the first case, so we're just gonna handle that matter really quick. Just temporarily, I'm gonna place you on mute, and then you'll have to unmute yourself when your case is called, okay?
Okay, I was just teasing.
Thank you. And Todd's the attorney, so I just brought them all in. Get them open, fix that.
All rise. 55th Circuit Court is now in session. The Honorable Roy J. Meek presiding.
You may be seated. Calling the case of Jane Teresa Clark versus Gregory Stephen Clark.
Thank you, Your Honor. Todd Dietrich appearing on behalf of the plaintiff, Jane Teresa Clark, who's appearing by Zoom from another room in my office.
Please the court, my name is Jeffrey R. Juniak. I'm an attorney from Gladwin. I represent the defendant, Gregory Stephen Clark, who's present to my left.
All right. Would Mrs. Clark and Mr. Clark please raise their right hands and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Mr. Clark, did you say I do?
Yes, I said, yes.
Okay, all right. Mr. Diedrich, you may proceed.
Thank you, Your Honor. Ms. Clark, you're the plaintiff in this matter, correct?
Yes.
And were the allegations that you made in your complaint for divorce true and accurate on the day that you made them?
Yes.
And do they remain true and accurate today?
Yes.
Do you believe that there's been a breakdown in the marital relationship to the extent that the objects of matrimony can no longer be achieved?
Yes.
Is there any reasonable likelihood the marriage can be preserved?
No.
Now, you understand that you had a right to go to trial in this matter, correct?
Yes.
And you understand that at trial you might have done better or you might have done worse, but yourself and I, as well as your husband and his attorney, we've entered in negotiations and we have a settlement in how this divorce would proceed. Is that correct?
Yes.
So a couple of things I have to ask you. Are you currently pregnant?
No.
And there are no minor children currently in this marriage. Is that correct?
Yes.
And you have not, well, you initially sought spousal support, but you're not asking for that as part of the settlement. Is that correct?
Yes.
And you understand that that issue is forever barred. You can't come back in the future and say you would like some alimony or spousal support. Do you understand that?
Yes.
Okay. So in terms of property, personal property, have the two of you already divided that property?
Yes.
And in terms of, there's going to be a $5,000 payment for your marital share of the Edward Jones account, and you've just received that today. Is that correct?
Yes.
And then Mr. Clark is going to be awarded the remaining assets in that Edward Jones account. Is that correct?
Yes.
In terms of the marital home, you're going to be sharing in the cost of the appraisal. Is that correct?
Yes.
And it's my understanding that you'll get 1/2 of the equity of the marital home within 90 days from the date of the appraisal. And upon payment to or by Mr. Clark to yourself, Mr. Clark would then be awarded the marital home, and that's known as 1881 Springwood Drive, Harrison, Michigan 48625. Is that correct?
Yes.
Now, if Mr. Clark is unable to refinance the home within 90 days of the date of the appraisal, the marital home and the real property would be listed for sale at the appraised value, or in the alternative at an agreed upon price signed in writing by both you and Mr. Clark. Is that correct?
Yes.
Once the marital home is listed for sale, should any necessary repairs be agreed upon by both of you, that you'll both be liable for 1/2 the cost of those repairs. Is that in order to make the home sellable? Is that correct?
Yes.
And then any proceeds from the sale of the home will be divided equally between you and Mr. Clark. Is that correct?
Yes.
In the meantime, Mr. Clark will be obligated to maintain the marital home and real property, paying all the bills, taxes, and insurance until such time it is sold. Is that correct?
Yes.
Now, in terms of any automobiles, you're going to receive any and all automobiles in your possession, free and clear of any claim by Mr. Clark, and you're going to hold him harmless on any debt thereon. Is that correct?
Yes.
The same holds for Mr. Clark. He will receive any and all vehicles in his possession, free and clear of any claim of yourself, and he will hold you harmless on any debts thereon. Is that correct?
Yes.
You're going to receive any bank accounts that you have solely in your name, and Mr. Clark will receive all bank accounts held solely in his name, correct?
Yes.
In terms of debts, other debts, any debt held solely in your name will be your responsibility, and you will hold Mr. Clark harmless on that, and any debts in Mr. Clark's name will be solely his responsibility, and he will hold you harmless on those. Is that correct?
Yes.
Any pensions, retirement benefits, anything like that will remain in the name of the individual who it's currently in. Is that correct? So if you have a pension or retirement, that'll be yours. If Mr. Clark has a pension or retirement, that would be his. Is that correct?
Yes.
Neil, you had an opportunity to review a proposed judgment of divorce. Is that correct?
Yes.
And I guess before I get to that part, you're asking for your name to be restored to Jane Teresa Potter. Is that correct?
Yes.
And that is not being done for any illegal or fraudulent purpose. Is that correct?
Yes.
And so you had an opportunity to review a 9-page proposed judgment of divorce. Is that correct?
Yes.
And you read that, correct?
Yes.
And you signed the last page. Is that correct?
Yes.
And did you sign that because you were in agreement with the contents of the proposed judgment of divorce?
Yes.
And are you asking the court to grant your divorce?
Yes.
And again, you had a right to go to trial. You could have done better. You could have done worse at trial, but you're asking the court to ratify the agreement that's been placed through this proposed judgment of divorce. Is that correct?
Yes.
And have you been satisfied with my representation?
Yes.
So I have no further questions, Your Honor. The court may have a different draft. We took a paragraph out regarding Social Security and added in a paragraph regarding the repairs. I'll get that over to the court with the signature page here in the next hour, if I can.
All right. The court doesn't have a copy of any judgment right now, so.
All right, we'll get that over to the court within the hour.
All right. Mr. Juniak, any questions of this witness?
No, Your Honor. Thank you for the opportunity.
All right, you may question your client.
All right. Gregory, state your full name for the record.
Gregory Stephen Clark.
And you're the defendant in this action for divorce. Is that correct?
That's correct.
And did you hear Mr. Dietrich put the property settlement agreement on the record?
Yes.
Did you understand it?
Yes.
And are you in agreement with it?
Yes.
Now, you've reviewed through proposed consent judgment of divorce, is that right? Or a judgment of divorce, I should say. It's not
Yes.
consent. And did you understand the terms of that judgment?
Yes.
And you signed that judgment, is that correct?
Yes.
And you want the court to enter that judgment?
Yes.
You understand you have a right to go to trial where you may get more, you may get less, or you may get about the same? Do you understand that?
Yes.
With that in mind, are you still asking the court to ratify and approve your judgment of divorce?
Yes.
Nothing further, Your Honor. Thank you very much.
Mr. Dietrich, any questions of this witness?
No, Your Honor, thank you.
All right. I just have a couple questions. I don't believe I heard it, but Ms. Clark, you were a resident of the state of Michigan at least 180 days before filing a complaint?
Yes.
And of Clare County at least 10 days?
Yes.
And Mr. Clark, you're not being awarded any spousal support. You understand that?
Yes.
You understand?
Mr. Clark.
Yes.
And you understand if you're not awarded spousal support, you're forever barred from receiving it?
Yes.
All right. Court finds that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed. There remains no reasonable likelihood that the marriage be preserved. The divorce shall be granted. Plaintiff's name of Potter, is that spelled P-O-T-T-E-R?
Yes.
Is restored. The court will sign the judgment of divorce. Upon presentation, it needs to include the statutory insurance clause, and the court will ratify all the terms stated on the record. Anything further from either party?
No, Your Honor, thank you.
No, Your Honor, thank you.
All right, thank you. Defendants can sign off, and the plaintiff can sign off.
Thank you, sir.
On the case of Donald Doak versus Peggy Sue Doak. Counsel identify for the record, please.
Thank you, Your Honor. Todd Dietrich appearing on behalf of Mr. Donald Doak. Your Honor, unfortunately, I think there might have been some miscommunication. Mr. Doak actually came to my office yesterday, and he was going to go up north for his daughter's college graduation. So I gave him the information to log on from Zoom, but I also see that we had the wrong judge on the proposed judgment of divorce. So I may have given him the wrong login information. I have attempted to call him, and I've also called over to Gladwin County because I just got out of court with Judge Evans to see if he tried logging on over there. They said no, but I've not been able to get through to him. So unfortunately, I am asking just for an adjournment to reset this and we can get everything set back up.
All right, reschedule it, and we'll be all set.
All right, thank you, Your Honor.
All right, we're in recess.
Thank you.
All rise. 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. Find the case of Sadie Lee Lyons versus Benny Bird. Counsel identify for the record, please.
Good afternoon, Your Honor. Caitlin York on behalf of the people.
Thank you, Your Honor. Todd Dietrich appearing on behalf of Benny Burge.
All right. And you are Benny Bird?
Yes, sir.
All right. Today was set for a hearing on a PPO violation. Has there been some kind of a settlement in this area?
Well, Your Honor, I didn't know that the prosecutor had an appearance in, but I would have contacted her earlier. But I guess the long story short is I believe Mr. Burge is prepared to plead guilty to the violation and with explanation.
All right. How old are you, Mr. Bird?
48, sir.
Would you raise your right hand and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely, I do.
You understand that the possible penalty for a violation of a personal protection order can be 93 days in jail and or a $500 fine. The minimum is discretionary with the court. You understand that?
Yes, sir.
All right. You're being charged with contempt of court for violation of a personal protection order. And you were served with personal protection order. Is that correct?
Yes, sir.
All right. And you knew about having a personal protection order on or about February 9th, 2021, is that correct?
Yes, sir.
Personal protection order was issued on February 8th of 2021. And were served with it. You were told that you had to leave the property, is that correct?
Yes, sir.
You were, personal protection order said you cannot be at that residence, is that correct?
Yes, sir.
And you refused to leave, is that correct?
I did, sir.
And in fact, the police officer gave you a couple of times. He asked you to leave and you refused to do so.
Yes, sir.
And finally, the officer arrested you.
I did let him know. Yes, sir.
Any questions on behalf of the people?
No, Your Honor. Thank you.
You satisfied with the factual basis?
Yes, Your Honor.
Satisfied with the factual basis, Mr. Dietrich?
Yes, Your Honor.
And you wish to go to sentencing today, Mr. Dietrich?
Yes, Your Honor.
I may be.
Yeah, but this is the time you get to speak now, before sentencing.
There were a lot of things going on in that moment. You know, a lot of ups and downs and a lot of heartfelt areas for me. I didn't understand a lot of it. lived my life, my heart, and always cared and loved, and took care of the people around me to ever be necessary. And I've always been good with my hands, you know, and I've always been a strong person, you know, and I love these children and I love that woman dearly and wholeheartedly. I'm sorry that all of this comes about.
Anything else? Mr. Diedrich, on behalf of your client?
Yes, Your Honor, thank you. So what I wanted to explain to the court, it was my understanding that there was a landlord that was kind of involved in this situation slightly before the PPO. And it's my understanding the landlord told Mr. Burge he had to move out of the house. And so he felt he was kind of being forced out of the house. And then he got some legal advice somewhere and learned that the landlord would have to legally evict him and that they couldn't make him leave without a legal eviction. And so then it wasn't long after all that process that the officer showed up and advised him that there's a personal protection order. I mean, it's clear that Mr. Burge is not very savvy in terms of legal knowledge and understanding. The officer told him he had to leave, but Mr. Burge had moved to this area from out of state. He doesn't know anybody. He didn't have any belongings except for his clothes. He had nowhere to go. And I think the weather might have been bad as well, and he didn't know where he could go or what he could do. And he did advise the officer that, you know, he wasn't going to leave, but what I'm asking the court is to understand that in the back of his mind, he had already been told he had to be formally evicted to have to be forced to leave. And so, you know, obviously the officer gave him every ample chance to follow the court's order, but I don't think even Mr. Burge even understood really that it was a court order. I've had very in-depth conversation with him. I was appointed to him originally, and I was my original plan while he was in jail was to you know, have him plead, do the violation, because I think there was a technical violation, because once he was served, he refused to leave the home, and the order was he couldn't be at that residence. But then the next morning, he advised that he wanted to discharge me as his attorney. And so I think he ultimately spent 34 days in jail with, you know, for this violation. And I would ask the court to consider that to be sufficient punishment. He has relocated. The petitioner in this matter, Miss Leans, I contact, you know, Mr. Burge didn't have anything. He didn't have any clothes. He didn't have anything at all. I think he's been just staying at some associate's house. And I contacted Miss Leans. I asked her personally if she wouldn't mind giving, you know, over his clothes. And she dropped those off. I think it was yesterday. And Mr. Burge was at my office today to pick those up. And so that wasn't any doing of his own. That was me just trying to help accommodate the situation. And so I'd ask the court to consider just time served at this point. And I've explained to him it's a court order. He's got to follow it. And despite his confusion, hopefully this is all behind him and he's got it figured out now. Thank you.
On behalf of the prosecution?
Thank you, Your Honor. Although I appreciate the explanation from defendant, I don't know how much clearer it could be when a uniformed deputy shows up, sergeant shows up with a PPO and says you have to leave. I don't know how much clearer it could be that he had to leave. There was a court order in the sergeant's hand in the form of the PPO. It was a uniformed officer. So we would ask that the remaining time besides the 34-day for credit, so I think that'd be 60 days roughly to be served in this matter, Your Honor. Thank you.
Leans or Lyons, is there anything you wish to say?
No, Your Honor.
Your Honor.
Your time to talk is up, so, okay. This is a first PPO violation in this matter. The court is going to assess you $200 court costs, $100 fine. How much are you charging for attorney fees?
I gotta figure that out, Your Honor. I'm sorry. $185, Your Honor.
$185 in court-appointed attorney fees. The court's gonna sentence you to the time served. It appears you were arrested on February 8th, and bonded out on March 13th. So how many days that is, if it's 34 or whatever. Ms. Lyons, the PPO is going to still be in effect. It has an expiration date of January 31st of 2022. Are you happy with that?
Yes, sir.
All right, so the court will leave the PPO in effect. So make sure you go over those terms and understand it. No contact, you understand?
Absolutely.
All right. Anything further from either party?
No, thank you, Your Honor.
All right, we're in recess.
Thank you.
All right.
All right, 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding.
You may be seated. On the case of Charlie Trent versus Michael P. Juliet. You are Charlie Trent,
Yes,
and you are Michael P. Juliet.
Yes, I am.
All right, we're hearing a motion to terminate person protection order. Would both of you raise your right hands and be sworn?
Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Ms. Trent, is everything that you wrote in your petition true?
Yes, sir.
And Mr. Juliet was an ex-boyfriend or roommate of yours, is that correct?
Both.
Okay. And also an ex-coworker?
Yes, sir.
And back in October of 2020, you told him he wasn't welcome around and you didn't want him to show up around you or contact you, is that correct?
Yes.
And then on or about February 25th of 2021, did he show up at your work?
No, he did not. He told my coworker he was going to.
All right. And then did he threaten you through a text, through the coworker?
He threatened that he wanted to start a fight, but I don't know if that was directed at me or the person I was seeing.
And his actions have made you uneasy, uncomfortable, and scared, is that correct?
Yes.
And so he texted your coworker on the 26th of February and the 26th of February?
I believe those are the right dates.
Okay. And on the one, he stated he would be coming to town and he wants to fight, and the other one, he called you a derogatory name, is that correct?
Yes.
And in that second text, he said he wanted to ruin your weekend, is that correct?
Yes, he said he wasn't able to make it there like he had anticipated because he had to work, but he did not want me to know that he wouldn't be showing up because he still wanted to ruin my weekend.
And on or about February 7th of 2021, he sent flowers and a card to your work, is that correct?
Yes.
And why don't you tell me what happened back in October?
So in October, my folks had been staying with me, and he came over and asked my parents where I was. They didn't tell him, but he found me at my friend's house down the road. We were having a campfire, and he crashed it, and he was making me extremely uncomfortable. So I went to leave, and he said that we needed to talk and started following me. I told him there was nothing to talk about. And he started punching himself in the face. So I just ran into my friend's house and locked myself in there.
And then there was a incident about being informed that he was watching you on a camera.
Yes, he told my coworker that he had been watching me on cameras at work, and I don't know how that was possible because I had the alarm company come in and check. There's no way to remotely access those. But he knew specific things that I had done, and he called my boss and told him some of those specifics. So one way or another, he knew what I was doing. He was keeping tabs somehow.
And back in October, November 2020, you had an incident regarding your house or your parents' house?
Yes, it's my house. I had my dad put locks on everything, and there's a slider. So I made a habit of putting a piece of wood in the slider to keep it, in case the lock wasn't able to get. And I came home twice, and that piece of wood was kicked in the middle of the room, and the slider was unlocked, but the back door was still locked. I have a dog that's a rescue, and she doesn't let strangers in the house or near the house. I don't know that it was Michael, but I'm almost positive it was, that he had been in my house.
Is there anything else you want to tell the court?
Nope, that's it.
Sir Juliet?
Yes.
Your response?
My response is yes. I will admit to being in the house one time, and it was her folks knew about it the first time. They had left to go up north for the weekend. She was new to using a fireplace. I did go to the gas station. I bought the dog a treat, which Sean Barron and Joe, I forget Joe's last name. I told them exactly what I was doing. Took the dog her treat and threw logs on the fireplace and left. And that lock she's referring to, I did see sitting in my tool bag because all of my stuff was at the house at the time. But let me tell you, for her to think that I'd crawl under the house to get in and not take anything that belonged to me still is false, because I'm totally not that ambitious. And let me guarantee you that. So the other two times I was never in the house. In fact, I'd only been back to Claire 2 other times. One was to clean up the cabin we were staying in, and the other one was to come get the paperwork so I could appeal this. As far as me sending her flowers and cards, the one thing she remained to leave out was that was on February 7th. That was 7-year anniversary of our son's birthday and death day. and I can almost verbatim tell you exactly what the card said, and it had no inkling of anything bad in it. The coworker thing, yes, I did do that with texting her coworker. I did say that, and that was just me being deceitful. I mean, you could pull my record and look. I've never had any kind of domestics. I've never been in trouble for fighting. Her and I lived together and worked together for 10 years, and we rarely ever fought. As far as, let's see, what else was asked about?
At Heather's house, showing up there.
Okay.
Oh, yeah, I did do that. I did do that. I did show up at Heather's house, but her dad did tell me where she was at. It's not like I went out looking for her. And I mean, there was only so many places she could have gone. And I did go down there and I did try talking to her, and I sat around the campfire for a good hour with everyone else and just was very quiet. And then when she got up to leave, she got up to use the bathroom. And, you know, I followed her and I said, can we go somewhere and talk? And she said no. And I did. I got angry, but opposed of me raising a fist to a woman or anything else, I did take it out on myself. I was angry. I was upset. You know, again, 10 years is a long time. And to have it swiped out from under your feet, it took a toll on me.
Ms. Trent, anything else you wish to say?
No, sir.
Mr. Juliet, anything else you wish to say?
No, I mean, I just don't want this. PPO has no inkling of anything I would ever do. And I don't want it on my record. I'm in Traverse City trying to start over. I do not want that on my background check. You know what I mean?
I don't want to be looking over my shoulder all the time.
All right.
You don't have to.
Ms. Trent, you're still afraid of what he may do, and you wish to have this PPO continued?
Yes, sir.
All right. The court issued it all the way through December 31st of 2022. Any objection if that got shortened by 6 months?
Not if he sticks to it and leaves me alone.
Okay. Well, if he doesn't stick to it, you can always do a motion to extend it during that period of time, okay?
Yes.
And you can also, if you find that he's violating it, you can call the police. If they don't do anything, you can do a motion to show cause to have them held in contempt of court for violating it. You understand that?
Yes, sir.
All right. Court finds that based on the pleadings from the petition, there was good reason to issue the ex parte personal protection order. It does appear that the petitioner is still afraid of the defendant and what he might do. So the court finds from the facts that there was some stalking going on, which is what the personal protection order is supposed to protect against. But the court doesn't find that it's necessary to keep it through the length of term through December 31st. So the court will reduce that by 6 months and issue a new PPO that expires June 30th of 2022. You understand that, Mr. Juliet?
Yep.
All right. So it's still going to be in effect, but we'll reduce the length of time and it'll expire early if you don't do anything. And after it's been in effect for a year, the court will say that if there's no problems as of March of 2022, the respondent can file to have it terminated earlier than June. Ms. Trent, you understand that?
Yes, sir.
All right. And any questions, Mr. Juliet?
No, other than I mean, it's a one-sided thing, but no, I don't.
Any questions, Ms. Trent?
Yes, is he allowed to contact my coworkers regarding me?
There's no third-party contact, so if he does, he's not supposed to be doing that, not about you, no?
Okay, thank you.
Okay, you understand that, Mr. Juliet?
Yeah, I have nothing to talk about her about anyway, so yeah, I do.
Okay. All right. We're in recess. The court will sign new orders. They'll be sent out. All right?
All rise.
Make sure we have their proper mailing addresses.